Let's go ahead and get started. My name is Alex Zhang. I'm the Associate Dean for Information Services at Duke Law School. It is my great pleasure to welcome you all to our Faculty Author Book Talk series. This year alone, we have hosted 5 Faculty Author Book Talks, and today marks our 6th one, and I also want to call it a grand finale because, as you can see, we're going to have some music for our 2024 to 2025 program. Before we begin the substantive discussion, I would like to thank Professor Gina Gill Fletcher and her office for sponsoring today's lunch. I would also like to thank our colleagues in Duke Law's Instructional Technologies Consulting and to my wonderful library partners, Jennifer Behrens and Shauna Bangro, for their consistent hard work in making this event and all previous events possible. Today, we're here to celebrate Professor Jennifer Jenkins' newest work, Music, Copyright, Creativity, and Cultural. It is published by Oxford University Press, and as a Duke Law faculty, staff, or student, you have access to this book in print through our library collection. Professor Jenkins is a clinical professor of law and the director of the Duke Center for the Study of the Public Domain, where she leads the ARTS project, exploring how intellectual property shapes cultural production. And we're truly honored to have Professor Jamie Boyd join us and lead us through I'm pretty sure will be a lively conversation with Professor Jenkins. Professor Boyd is the William Neal Reynolds Professor of Law at Duke Law School, and he's the founder of the Center for the Study of the Public Domain. And now, without further ado, please join me in welcoming Professors Jenkins and Boyd.
So thanks so much, everybody. This is a wonderful, or possibly, it involves a wonderful opportunity, although also possibly a conflict of interest, given that I am married to the author. With this kind of conflict of interest, I might well end up in the cabinet. Jennifer has written this book with Oxford University Press. We've published books together, and if you think paddling a double kayak is a test of a relationship, writing a book together is even more of a test of a relationship, I can tell you that. But this is entirely hers, which is why I get to cavil about it and say how wonderful it is. So when I was reading the book, preparing for today, it struck me that there are 3 moments in my life where I wish I had had this book. The first was when I reached the age of musical maturity. That is to say, the first time I bought music for myself with my own money. I was 11. 2 cassette tapes, Simon and Garfunkel and King Crimson. I think it's pretty good taste for an 11-year-old, actually. I mean, it's pretty solid. The reason that it would have been useful then is it would have given me some sense of how the music I was listening to got to me and the forces, legal, technological, economic, that shaped it. The second time when I would have loved to have this book is when I entered college and was struggling to have the epiphany that I hope you all had in college, which is that reality is interdisciplinary. It doesn't live in one department. It doesn't live in the economics department or the politics department or the engineering department. It lives or the history department. It lives in all of them simultaneously. And this book, because of the way that it explores all of the forces that shape our music, the historical forces, technological, economic, legal, would have been just the thing to spur that insight. And then the final time when I wished I had it, and this may be of some interest to some of you, is when I was taking 1L property law and was in a fog. I knew vaguely that the shape of the rights was something to do with the shape of the resulting economy, but the details of how that actually worked out in practice were very obscure to me. And I think using the example of music, something about which we all care, something about which we all have, with which we have some familiarity, would have been a great thing for me. So to jump into the book, Jennifer, congratulations.
Thank you.
So you start the book with this wonderful thought experiment, which is that you, and I'll put all of you in this role, have been nominated as the czar for Musicland. A new administration has said to you, we're starting a whole new society. Things in ours just weren't working out. We're starting a new society. We want to have music. The sky's the limit. How do we get it? What's the method by which we get music? And you explore all kinds of ones, including some I'd never thought of, including just leaving music as a completely amateur activity, so that making music is kind of like being a great conversationalist, right? Might make you much in demand at dinner parties, but it's not really like a profession, except I guess if you're a talk show host. But then you move beyond there to ones that we're more familiar with, and I'd like to focus on two. The first one is patronage, the idea that the music is incentivized by having a patron, often an aristocratic patron, support the composer, support the musicians. And then the second one is the move from patronage to copyright. So can I ask you to explain a little bit about the kinds of music we get under each of those systems, and perhaps even to tinkle the ivories to demonstrate?
I think tinkling is too generous. Thank you for that very generous introduction, dear. Yes, Jamie was there watching me agonize over the book during the pandemic. But let's talk about what kind of music was produced under patronage. So it was the kind of music, may it please the court, right? But in this case, the royal court. It was what the aristocrat wanted. It was what the church wanted. It was what the king, it's what the emperor wanted. It was performed by professionals. Not me. And I thought, okay, what am I going to play from patronage? Well, I went to the archetypal composer during patronage, J.S. Bach. And I also had to choose something that my very rusty ability could actually play. And so I came up with this. Listen to what it sounds like. I didn't come up with it. Bach came up with it, but I'm going to play it. And I'm going to crank the organ, just because we're talking about church music here. So, oh yeah. Okay. I played that when I was 6 correctly, and now I'm like 53 and can't play it. But the point being, okay, so Bach was employed as a composer, right? As an employee during his entire adult life. What kind of music did we get? The kind of music that people who play better than me could play. That was actually a Bach invention that those of you who played music, he wrote it for his 12-year-old kid and his students so that they could figure out how to play something like the Goldberg variations. But that was the kind of music that we got under patronage. But then we have a shift. We have a shift to a market-oriented system, to music copyright, where the people paying for the music are different, the technologies are different, the markets are different, and as a result, music is different. So copyright in the United States was first extended to music in 1831. A lot of things going on in the 19th century, but one of them was mass production, the Industrial Revolution. So think about the Industrial Revolution as applied to pianos. For the first time, we had the technology to mass produce pianos, to make them affordable so that people could have them in their homes, in their middle-class drawing rooms. And so the person paying for the music, deciding what kind of music is going to be made, is no longer the emperor of this, or the duke of that, or the church. It's the people who are buying the sheet music that they want to play on the pianos in their drawing rooms. So the music's going to sound different because what do you want? You want something that's appealing to the aesthetics of, in this case, a lot of middle-class women. You want something that you could actually play on the piano with your middling skills, preferably something that sounds kind of complicated, but is super easy to play. So I have, I'm about to play you, so my students, thank you, AK, introduced me to this person named Sabrina Carpenter, who I think of this and it was you. This was as popular as like the Chapel Roan, the Sabrina Carpenter, the Taylor Swift of the late 1800s. It's one of the best-selling waltzes, and it was best-selling because people could play it and dance to it in their homes. And so what did it sound like? I'm doing all of this from memory, so let's see. You ready? Why was that? A pianist I am not anymore. But why was that popular? Among other things, because of the glissando. So the glissando, keyboard cat could do this, right? The glissando, instead of playing the notes with your fingers, you just take your fingernail, you put it on the keyboard, and you go, and it sounds like a wonderful flourish. And so that is an example, concretely, of the new technology of mass-produced pianos, the new market for sheet music, the music people actually wanted to buy, wanted to hear, were able to play, affecting the way that music actually sounds. Sounds a bit different from the Bach that I just played.
Excellent. So we've got two axes now. We've got the incentive structure, now based on copyright, the right to stop people from copying your music, which also allows you to sell your music to people. In this case, the people who are actually playing it and listening to it or singing it. But you also bring in something else, namely the technology, and that's one of the other axes that you discuss. And so the piano, we don't think of the piano as a technology, but obviously as what you were saying is that we'd applied the mass production skills of the Industrial Revolution to pianos. So pianos that used to be handmade, used to be incredibly expensive, could now be in everybody's drawing room, not everybody's drawing room, many people's drawing room. But can you take us through some other technologies? And in particular, I was thinking about what I think is the most transformative music technology of all time, which is the development of recorded music. So that for the very first time ever, if you're going to listen to music, you don't have to be the one playing it, or you don't have to hire someone to play it for you, which is just, it means far greater than anything we've seen in our lifetime. That this was just a transformative experience. And so that obviously changes things, because now I don't have to make music for people who can do glissandos. I can have a virtuoso actually playing it. And then the other one is the development of radio. And radio takes these recordings, but then distributes them effectively to a mass market without the people buying them. They're just listening to them. How did those change the music that we listen to?
Dramatically. And so what the book is, what Jamie said, the book follows this march of technology, law, aesthetics, economics, and how they all interact in the music ecosystem. So what I just demonstrated, this is sheet music, right? This, at one point, this was what the form that music was sold in. That's our vision of the steampunk creation of pianos in middle-class drawing rooms. But then we had, as Jamie described, this seismic revolutionary change. So it's hard for us to imagine, but there was a time when to listen to music, you needed a human intermediary. You couldn't just listen to it, right? You needed, preferably not me, to play it for you on the piano or to sing it. When this is an actual Edison cylinder, from the beginning of recording technology. So imagine if this was an LP or you know, a vinyl record. This is a sort of unmarked wax cylinder. With recording technology, now for the first time, you could listen to music in your own home from a machine without a human intermediary. Well, back to the copyright story, what happens then? There's a new market, right? Not the market just for the sheet music that I showed you, but a market for the recording. There's a new industry, the recording industry. And copyright law eventually catches up. There's a new compulsory license that those of you in Professor Buckafusco's copyright class first learned about, the compulsory license to make mechanical reproductions. This is a mechanical reproduction. This is a mechanical reproduction, instead of a copy written out by hand, these. And later, a separate right, we call it the Circle P right for phonographs, for the recording artist, or more likely the record label, over the sound recording itself. And so we have the initial, what we call the splitting of the atom in music copyright, which have two separate rights over every piece of recorded music. One is owned by the composer or the publisher or the songwriter over the composition that you might think of as this. And a separate right that's owned by the performing artist or the label over the elements of their performance that are fixed in the sound recording. So this is about the turn of the 20th century, and then a couple decades later, we have another revolutionary technology, the radio. Let's talk about the changes that radio brings. For listeners, for us, for fans, before you had to find the music. You had to go to the concert hall. You had to buy it and play it in your living room. You had to buy the recording and listen to it. With radio, now the music finds you. What about the business model? You used to be selling this. Used to be selling this. With radio, this may sound familiar, you're actually selling the attention of your listeners to advertisers. That changes the kind of music that becomes popular. That changes the kind of music that gets rewarded. Excitingly, if you're a performer, now your audience isn't limited to the people who buy your recordings or the people who come to your concerts. You can be a celebrity. You can be Taylor Swift. You could be Sabrina Carpenter. You can reach millions if your song is playing on the radio. And excitingly, music also crosses racial, cultural, and geographic boundaries in a way that it hasn't before. So how does that change the way music actually sounds? If you're a radio station, the early days of radio, you want music that gets people to tune in and keeps them tuned in. You want radio-ready hits. You want earworms. How does the law react? At first, radio stations were not actually paying royalties to the composers whose music they were performing on the radio. They saw it as free advertising. They said, listen, how are people ever going to go out and buy your sheet music or your recording? Maybe they'll hear it on the radio. But eventually we got copyright. We got something called the blanket license that some of you guys have heard about that are administered by the performing rights organizations, ASCAP, BMI, GMR, CSAC. And so you see this change happening again for listeners, for performers, for copyright, and for the way that popular music, at least, actually is going to sound.
So I get the change there. So we had patronage, and so it's music designed to please the king, and then we got radio, so it's music designed to sell the king of beers to the people listening to the radio. That's obviously going to change dramatically the music you listen to. Probably will also change the length of the music that we're listening to. So we have the dictates of how long an LP could be. We have the type of music that's being put on there. And I guess I'd love it if you could take that story and fast forward again and move forward into the realm of streaming. So on the way here, I was listening to the radio, and I'm listening to music. And then at a certain point, I became irritated with what was playing on the radio and turned to going through Bluetooth from my phone, which has got a streaming service attached to it. So I'm now getting out of Pandora. As far as I'm concerned, the music's coming out of the same speakers, right? And in many ways, because I'm old, the music that I'm listening to similar types of music, though the algorithm's giving me some things that I might not have picked myself. But it is nevertheless apparent to me that music has changed dramatically in the streaming era. And it's not just the business model, right? Because the business model is relatively similar. It's not just advertising. It's actually all of you either paying for streaming or using somebody else's streaming password. And that's how you're getting your music. So it's not as much advertising. But again, it's people want popular music. So how does the move to streaming change things? And in particular, how does it change the political economy of the music?
In so many ways. So here's some of the streaming services that you or your friends may use. So as Jamie was saying, from his perspective, he's just listening to music. There's a lot going on behind the scenes that determines the difference between the music you might be hearing that might be rewarded by terrestrial radio and that might be rewarded by streaming. What's going on behind the scenes? One is a massive amount of data. So I don't know if you guys have looked into what Spotify is tracking about you, but we've moved, the tastemakers have moved from the DJ in Paola, which I know Chris has written about, to the almighty data-hungry algorithm. So Spotify tracks down to the millisecond everything you hear, when you pause, when you skip, what you're searching for, connects it to what the weather's like outside. Maybe you were listening to a little more mopey music today after the Duke loss in the rain, right? Connects it to your demographic.
Way too soon. Way too soon.
So sad. Connects it to the demographic data and more than you could possibly imagine. All of that data feeds into the algorithm. There's no, that kind of tracking didn't exist when in the days of radio. Now all that data is fed into the system, and among other things, Spotify knows exactly how long you listen to something, and guess what? They don't get paid. The artist doesn't get paid unless you tune in and stay in for at least the first 30 seconds. So that's one of the first things that's going on behind the scenes, and I'm going to show you how that changes the actual structure of songs, not that Cliff plays, but popular economically incentive-driven music that you get, the top 10 hits. But what else is going on behind the scenes? So this is a charmingly complex chart. This is a simplified version that my music copyright students know. The book is chock full of charts and this sort of thing that illustrates some of the differences behind the scenes in the licensing framework, who gets paid, how, what radio has to pay, what the recording industry had to pay to make those LPs or that CD, and what streaming services such as Spotify have to pay for a single song, a single piece of recorded music in order to put it out there. So this is, we're talking about data. This is something else that's going on behind the scenes. So I mentioned the compulsory license. you're making a recording, you're the recording industry, you have to pay the compulsory license. It's called mechanicals in the music industry. That's a single license. What did radio have to pay? I mentioned that too. The blanket license that's administered by the performing rights organization. Terrestrial radio, not talking about internet radio, but terrestrial radio. Streaming service, for a single song, 4 different licenses. Not because this makes any sense, not because someone stepped back and said, wow, this would be the most efficient way to handle licensing in the streaming era, but because every time a new technology comes along, we don't raise the system and restart from scratch, we just slap another license on top of it. So if you're Spotify, it took Spotify, some scholars estimate that it took Spotify 42 to 48 months to get all the licenses they even needed to get up and running in the US and the EU. By comparison, Napster, that's back in the news now because they're in the metaverse for reasons best known to them, they only operated from start to finish until they were shut down for 2 years. Even Grokster only operated for a little more than 4 years. So this is just the licensing. Why do they need as many licenses? Well, reproduction and distribution. They have to get a mechanical license for all of the copies that are made because of the way digital technology functions in order to stream you a song. Public performance of the composition, think of the sheet music there, because like radio, they're streaming, they're performing the song for you. But they all have to get these licenses as well. Reproduction and distribution of the recording artist right, the sound recording right, and something that we added in 1995 to the copyright scheme called the digital audio transmission. I won't bore you anymore with music licensing, but the point being, radio, 1 license. Mechanical reproductions, recordings, 1 license. Streaming, 4 licenses for every single song. So that's another thing that's going on in the background, but more excitingly, I could see Jamie's face, like, get to the good bit. But how does all...
She does this at home too, but never with wine for some reason. I don't know why.
I'm very funny at home. You can trust Jamie on that. The ergonomics of this are a little strange. How does this change the way music actually sounds? You may not notice it, but in some dramatic ways. So there was a time when most popular music, 9 out of the top 10 hits had a familiar to some people verse, chorus structure, right? You get the introduction, you get the verse, it builds, you get the chorus, verse, chorus, maybe a bridge, and you go on for there. So in 1999, 9 out of the top 10 songs were verse, chorus. In 2019, only 3 out of the top 10. So I'll give you a demonstration of this. I had to bring some Deep Purple into this, and so do we know who Deep Purple is? Smoke on the Water? Okay, listen to this. Listen to this driving. Haley, are you out there? Okay, I'm showing your video. The verse with the introduction. That's the intro. This is the verse. We all came out to Montreux on the lake Geneva shoreline. Okay, what's the chorus? Now, even though they got the driving beginning, right? So I know Jamie wasn't very into the verse part. Why are they all going out to Montreux? I don't know. But now what's happening? If you want people to stick around for the whole first 30 seconds before that guitar intro, so you're going to get paid and they're not going to just push the button and skip to the next song, you might want to front load the chorus. You might want to front load the hook. You might want to front load the featured artist. You might want to do what Tay-Tay does and just start the whole song with the chorus. Let's listen to this. I wanna be your end game. That's the chorus. I wanna be your very first second of the song, she busts in with it. Kind of keeps you listening. Then it keeps coming back to tease you again. Or you might do this. You might do what Bad Bunny does and just have a whole bunch of versions of the hook that play throughout the song. So here is Bad Bunny. And this is, so I want to credit Nate Sloan and Charlie Harding with the New York Times. They diagrammed the song this way. But I'm just going to play you hook A, hook B, and hook C from this song. Keep you listening, okay? And you kind of get the groove of the song. So this is hook A. This hook B. Hook C. So you have different versions of the same thing. And if you like that groove, You're going to keep spending your time with Bad Bunny, right? And so a number of commentators, this isn't me, have attributed sort of the death or the diminution of the verse-chorus form that dominated popular music to this new way of structuring songs because of the realities and the data and what songs get rewarded in the streaming economy that we now live in. Songs are also shorter. So say you spend 3 hours listening to music every day. If every song's shorter, then that's more money for each one of those chunks of the 3 hours you're listening to music. And I don't know if you guys think this is true. There have been some people who say that because of the algorithmically driven music curation, that we get less less complexity, less strange, less obscure music because the algorithm has the effect of sort of amplifying and reiterating whatever the trending songs are, and they replicate what catches on, sort of prioritizing simplicity and catchy melodies. So that sounds very elitist, but that is also, that trend, at least in the top 10 or the top 20, has been attributed to the economics and everything we've been talking about behind the scenes with the streaming era that we now live in.
Right, I mean, you're not gonna get Bohemian Rhapsody. Right? You're not going to get Queen. You're not, right? I mean, you're not going to get long intros. I mean, the beginning of Stairway to Heaven. Like, get to the point, right? So Jennifer says it's like, some people have argued. It's like, it's worse music, is the way I would put it personally. Not that there isn't fantastic music there. Not that there isn't a greater diversity of music, but what we're being fed is highly optimized in a way that it never was before, data down to the millisecond. People didn't know when you turned off the radio. Right? Now they know exactly what you're doing. And the result is not necessarily net in our overall interest. Are you going to get a transcendent song? I leave it up to you. Sometimes, right? But I wonder if as much. So if we can transition to another aspect of the law, if that's okay. So copyright was a legal form that was never invented for music. Copyright was, unsurprisingly, built around books. And a lot of copyright's assumptions are rooted in a world of literary creativity. So Shakespeare had a working vocabulary of 31,000 words. That's how many words he uses in the play. We know he used those words because he uses all of them. Probably had an actual vocabulary of 60, 70, 80,000 words. There's the musical scale. Not as many as you may have noticed, right? And so what we have is an assumption with literature, which, and even in literature it may not be true, the creativity is like a fountain. It just diverges infinitely. My novel's not going to get in the way of your novel. And although they might share a boy meets girl plot, there are going to be enormous differences. But now when we take all of that stuff and we apply it to music, it seems to me there has to be a change. And the sort of, I mean, a lot of you went to law school because your parents thought it was a prestigious occupation, and you've now realized that what you do is fill boxes for a living. It's just that the boxes are conceptual boxes, not cardboard boxes, right? That's what we do. We put things in boxes. Well, does music fit in the cardboard box of copyright?
No. Hey, it depends. Actually, yes, no, not very well at any rate. So one of the first reasons that music is so very hard for copyright to handle, with all of its doctrines that were developed and calibrated for literary works, is because of what Jamie was just talking about, the limited musical vocabulary. And so I don't know how many words we have, probably not as much as Shakespeare. You probably know like 40,000 words, right? I know maybe like, yeah. But this is a major scale, has 7 notes. And then you repeat. Even the chromatic scale, all the notes, that's 12 notes, and then you repeat. That's a much more limited vocabulary. Yes, you can put the notes together in a lot of ways, but to quote Judge Learned Hand, because you will never get through a copyright speech without someone quoting Judge Learned Hand, it must be remembered that while there are an enormous number of possible permutations of musical notes on the scale, only a few are pleasing, and I'm about to diss unpopular taste here, Hand is, and fewer still are pleasing to the infantile demands of the popular ear. So yes, he's dissing unpopular music. He would not have been a Swiftie. That's okay, we'll forgive him that. But his point being that, yeah, there's a lot of reasons, there's a lot of ways you can arrange notes, but no one wants to listen to this. Right? You want to listen to combinations of notes that please the listener. You add to that the conventions of genre, or form, and then you add to that the traditions of borrowing bits in music, and coincidences are going to happen. With all the songs out there, a lot of songs working with a set of notes, and I'm going to demonstrate that with Led Zeppelin and Ed Sheeran in a second, are going to sound the same. Well, enter copyright. Copyright. A lot of songs sound the same. What happens when you go into court and someone says, hey, that person ripped me off, their song sounds like mine? How do we know if there's copyright infringement? How do we know if it's coincidental? How do we know if it's inspiration? How do we know if it's theft?
So you also bring up something else beyond just the more limited vocabulary in which we create copyrightable expression within music. In literature, as you will definitely learn if you take our intellectual property class, copyright is trying to do two things. It's trying to define the realm of property, what it is you own, but at the same time, and equally important, it's trying to define the world of the public domain, of the commons. That's vital because it is from the public domain that the next generation of artists, writers, creators are going to do it. It is very much part of IP's ambit. In copyright as applied to books, there are fairly obvious sort of retaining walls that protect the public domain. Copyright never covers facts at all, period. We're done. Copyright never covers ideas. Never at all, not ideas. Expression, yes, not ideas, not facts. And we have fair use, right? So those are three things that are designed to basically protect a commons that the next generation can build on. The facts in my book go immediately into the public domain. No need to wait for Life Plus 70. So can you tell us a little bit about how those sort of retaining walls, those defining features of the commons work inside of music?
Not terribly well. So yes, these were developed for literature. Look, you read, I mean, I'm not going to call this a work of literature, but if you read my book, you will find ideas in here. Copyright is, music is hard for copyright to handle. You will find facts in here about the history of music copyright. You know, I played you some Bach, right? What's the idea there? It's hard to define a musical idea. If that's one of the safety valves, if that's one of the retaining walls that ensures that ideas and facts are always available for future creators, that does very little work in the musical context. The Ninth Circuit kind of gave up and said, music is an art form that produces sounds and expressions and moods, but does not necessarily communicate separately identifiable ideas. Similarly, what is a musical fact? If a fact is something that you can say is true or false, something you can disprove or prove, what are the facts that I've just conveyed to you in that series of notes? And so this all important, what the Supreme Court calls a safety valve in copyright that ensures that we have that balance between what's controlled and what remains free for future creators. Idea and fact does very little work. The other safety valve being fair use. Fair use does surprisingly little work in the music context as well. Almost all of the fair use cases involving musical works have involved parodies, and the parodies were clear from the lyrics, not the musical content. And so these two traditional contours or safety valves in copyright that do a lot of work in the literary context and with other art forms do very little work with music. And I'm going to play you one more thing because I need to. On the subject of borrowing in music and Deep Purple, here's another example about demonstrating why convergence, coincidences, echoes happen in music.
I listened to Ludwig, Beethoven, bum, 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 bum. And I thought, play that backwards, put something to it, and you've got bum, 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 bum. That's how I came up with it.
Hang on. Are you telling
I love this guy.
that the famous riff of Smoke on the Water is from Beethoven?
It's an interpretation of inversion. If you turn it back and play it back and forth, it's actually Beethoven's Fifth. So I owe him a lot of money.
So that's a guitarist from Deep Purple, but that's not an example of something like Beethoven's Fifth. He's working with that inversion, he's working with those notes, and that guitar riff that you heard that rocked out was based on that pre-existing form. Whoops. Sorry, I got too excited. Okay, so there's our balancing act between control and freedom there. That's a little more complicated in the musical context. Would you like to hear about some case law?
I would love to hear about some case law.
Excellent. I'm sure everybody else would too. So one of the inspirations for this book is, so one of the things I love, and people who took music copyright know this, we're still trying to get this balance right in music. And a handful of the most important cases in the history of music copyright happened in the past 5 years, since 2020. We've had music copyright since 1831.
So can I pick up on that?
Yes, indeed.
We've got two complicating factors so far. One is the limited vocabulary. The second is that the conceptual boundaries around the public domain don't transfer as well. But then there's a third, which you spend a lot of time on in the book, which is the fact that all of us can read a novel, we can read a screenplay. If we're jurors, we can say, how similar are these, right? We can watch a movie and go, how much is that the same? But most of us don't read music. And most of us probably lack, in the same way that we would have in some other art forms, a sense of what the genre-defining components are, just the utterly standard things that are just part of making music itself. And so there isn't just a difference in vocabulary, there isn't just a difference in the retaining walls around the public domain. You argue, I think very persuasively, that the difference in knowledge of both judges and jurors is a profound difference. Can you expand?
Yes, so all of that comes together to explain the remarkable sort of shift recently, very recently, in the music copyright cases. So what we see coming forward from the days of early copyright, when I showed you the mass-produced pianos, is eventually how musicians get paid. That economic incentive, going all the way back to music land, starts to clash with how music is made when we have copyright claims over increasingly basic building blocks of music. And so the cases that we've seen recently involve not 10 bars of a piece, not whole swaths of a piece, but sequences of a few notes, or a basic chord progression, or a basic rhythm. And when that starts to happen, then the incentive, right, I want my copyright, how I get paid, gets in the way of how music gets made, because if a potential claim from someone else might actually interfere with the raw materials, the building blocks that I need to make my music in the first place. And so setting the stage for, this is the all-time best complaint ever created. Do you see that font from Houses of the Holy? You said it was a Rene McIntosh. Looks like Art Deco.
Charles Rene McIntosh, yeah.
To my knowledge, this is the only complaint actually filed in court where the lawyers thought that they would actually reproduce the Led Zeppelin font, and so I deeply appreciate that. And they also made up a new claim. They claimed that Stairway to Heaven was infringing their song, but they also said that Led Zeppelin was guilty of falsification of rock and roll history. And the court said, we're not aware of this. We don't see it anywhere in the code. I don't think that actually exists. But let's talk about the Led Zeppelin case, because this is the en banc decision from the Ninth Circuit in 2020. Setting the stage before the Led Zeppelin case, what had happened, you probably heard of the Blurred Lines case that sent shockwaves through the music industry. The claim at issue of the Blurred Lines case was over what they called a constellation of pretty standard basic musical building blocks. An A chord there, some repeated eighth notes there, a few scale degrees over there, a bass line that starts on the most common tonic on the first beat. All of those things together were the basis for one of the largest jury verdicts ever in the music context. So when this case got going to the Ninth Circuit, the music industry was seriously freaking out that the rules had been changed, that the line had shifted between what's owned, control, and what was free for future musicians to use. Briefs were being filed by, not me, not Jamie, not Jerry, by the Publishers Association, by the RIAA, the biggest copyright holders, saying, listen, we got the balance wrong, we got to do something about this. So what was the music at issue in the Led Zeppelin case? First, remember I showed you that circle C and circle P on that really convoluted chart that made Christina's face go, ah, before? I'm first going to play you the sound recordings at issue here. Now, the sound recordings include the underlying compositions that are owned by the songwriters, but also the way those compositions are performed. And one of the complexities in music is we're supposed to sift them out. They're supposed to be separate. And my guess is you're going to listen to these and say, my God, that's a huge ripoff. But then let's step back and think about what was actually copied from the original composition. So the original composition, all the way back from 1967, is a song called Taurus by the band Spirit. Were you guys like, oh my God, it's Stairway to Heaven? Okay, wait, I'm gonna unpack this for you in a second though. Okay, here's one of the best selling songs of all time. And have you seen Wayne's World? They're like, no, Stairway. I don't know if you remember that, but anyway. And how many people a little worried for Led Zeppelin right now? Few people? Well, what's the similarity between the songs? And so one of the weird things about music copyright is first we have to filter out the performance elements, the elements that fall within the separate sound recording copyright. And one of the things that happened here is the sort of fretting style, the sort of Renaissance, sort of mystic atmosphere, all of that, which you hear in both songs. They were both songs from the late 60s and the early 70s. That's off the table. And so what really are the similarities between those two introductions? And the rest of the songs are totally different. We're in A minor, so you can hear did you hear that descending chromatic figure? And then on top of that, there was just the basic tonic chord, the A minor chord. The tonic chord is the home, like with 1, the most basic chord on the first scale degree. So does anyone know doing a tonic chord? Wrinkle number 2. This is the deposit copy that was actually submitted. That informed the scope of the composition. And so one of the weird things in this case is what the jury was looking at was actually a version of the original song that did not sound like what you just heard. So I think you wanted this, Chris, right? What did they actually hear in the courtroom when comparing the two compositions? This is what they heard from the original. So there's a lot more different stuff between the familiar. But just unpacking your gut reaction when you first heard the songs to the fact that we're dealing with this. Can anyone claim that? Can anyone claim this? Might it be that these elements recur sometimes in other songs? Do you hear that? Do you hear the descending crown of da?
On a dark desert
Go down a half step.
cool wind in my hair, warm smell of colitas rising up through the air.
Buddy Valentine, they played this in chord. It's gonna go down in chromatic. Beatles again. My personal favorite.
Chim chimney, chim chimney, chim chim cheree. A sweep is as lucky can be.
A lot of minor scales, a lot of descending chromatics. The upshot of this, basic musical building blocks that you can't own in isolation or in combination, descending chromatic, short sequences of 3 notes, and arpeggios. Arpeggio is a chord, but it's broken up, so you play the notes separate. The Ninth Circuit, the en banc opinion said, those are free. No one owns those. Anybody can build upon those. Fast forward, yay. But initially they sounded the same, didn't they? And so this is bringing the limited vocabulary point, the control and freedom point, the difficulty of comparing musical works point together. I'm not saying Led Zeppelin didn't rip people off, because they did, okay? They ripped off, including African-American artists and famous blues artists. And normally they just paid up. But this case, they fought to the death. And in my opinion, were right to do so, because no one owns those musical elements. Second case. This is the guy that played at our centennial. Some of you guys were probably at his concert. This is the late, great Marvin Gaye. So listen up for the similarities between these songs. And I wonder what your gut reaction is.
I've been really trying, baby, trying to hold back this feeling for so.
Okay, so the lawsuit is from the heirs of Ed Townsend, who was the co-author of Let's Get It On, against Ed Sheeran for Thinking Out Loud. And I am actually very curious whether you think there's any there, just based on your gut reaction.
No.
I'm not singing, thinking out. Let's try this again. Start, start, start. There we go.
When your legs don't work like they used to before, and I can't sweep you off of your feet, will your mouth still remember the taste of my love?
Who's stressed for your Ed Sheeran? Nobody?
Yeah.
Okay, this went all the way to the Second Circuit. It was just decided last year. But in this case, we're not talking about descending chromatic figure. We're not talking about arpeggios. We're talking about a really standard chord structure. So the chords in Let's Get It On are this. Involving the 1, 4, and 5, which are the most common chords in all popular music. Ed Sheeran's doing this. The second chord's actually different. That's it. So utterly basic chord progression and an anticipated rhythm where the second chord comes in a little earlier than the downbeat. A lot of people were more impressed by the similarities than you guys were. Guess what? No one owns a chord progression plus an anticipated rhythm, and I have a reason for that too. Ed Sheeran, among others. Can we a moment for the courtroom artist?
It's not a guitar. I mean, he's playing a cello.
He's like, and I have my ukulele here, and my head's like going sideways. But anyway, yeah. So an unfortunate drawing. Ed Sheeran was in court, got past summary judgment on one of the things, and guess what he did? So the smoking gun for the lawsuit against him was he was at a concert in Zurich, and he actually mashed up "Let's Get It On" with "Thinking Out Loud." And they said, "Ha ha, you must have copied it." And so he got in court, took out his guitar, and he said, "Well, why don't I play a few other songs that actually sound very similar to you, and see if you can hear the same chord progression from Let's Get It On in the background."
I can hear her heartbeat from 1,000 miles.
Shania. Exactly the same chords.
She takes just like a woman. Yes, she does. She makes love just like a woman. Yes, she does.
So Sharon's point being that pop music's like Legos, it's modular, right? These are the basic building blocks that if those were owned, then it would have been very difficult for Marvin Gaye and Ed Townsend to create their song. Their song's brilliant. We're not talking about Let's Get It On and how brilliant the whole song is. We're talking about whether you can make a claim based on the fundamental basic backbone chord structure in the background of your song. And the Second Circuit, again, this movement, the Second Circuit just last year in 2024, after this litigation was appealed, said no. That material is not subject to copyright protection and anyone can use it. And this is a pretty good quote. Again, this is we just need to appreciate the talent. The courtroom artist is almost as good as I am on the piano here. With regard to the smoking gun, they were like, yes, but why did you mash up those two songs in Zurich? And he said, well, frankly, if that means I was ripping off Let's Get It On, I would have been an idiot to stand in front of a stage, in front of 20,000 people and actually demo that. So the smoking gun was shooting blanks, as his lawyer said. Final point, this happens often in music copyright litigation. So I don't know how many of you read music? A handful of people. Really? Awesome. What you see in music copyright litigation is this is what Jamie was talking about earlier. It's very hard. Often members of the jury are chosen during voir dire to not have the musical background that all of you have who raised your hands because you don't want to be biased on either side. Judges often don't have musical backgrounds. And so you're presented with something like this. And look at those numbers. And look at those red notes. The melodies of these two songs sound nothing alike, by the way. This is a claim that there are melodic similarities based on the recurrence. Remember I played you 7 notes on the scale? Based on the fact that some of these notes, these are the same notes in Camptown races. These are very basic standard notes, recur in different parts of the song with different durations and different placements. That's not what a melody is, right? It's not an abstracted sequence of notes. It's how the notes actually sound, where they are, how long they last to the human ear. But this is one of the prisms through which music is filtered that makes these music copyright cases so inconsistent and so difficult to decide and has accounted for some of the movement in the past 5 or 10 years in this space. And so we've got the limited vocabulary, the trying to balance control and freedom, the difficulty of comparing musical works, particularly for people who don't read music, all coming together to explain this, I think, fascinating shift that I talk about in the middle of my book, which are the recent cases really trying to get that balance right and to establish in the very copyright-heavy Second Circuit New York, Ninth Circuit California, that certain things are just going to stay free, even though they appear in different pieces. Do we have time for the sampling? No, we should move on.
Well, you were gonna mention reggaeton and possibly sampling.
I'm skipping reggaeton, but
okay. See,
one.
You got to take the class. You know, she's got to leave you wanting something. She's not going to give it all.
I know he promised his class that Bad Bunny.
Okay, but how about very quickly? So one difference is that we have, not on the reggaeton, but on sampling.
Yeah.
The difference between sampling and quotation's been going on since there was music. In sampling, people are actually using a recording of a prior work and putting that in there. Now, you would think, in theory, that should make no difference. It's the copyright is the copyright. But actually, the courts, mistakenly, and the recording industry, deliberately, have decided to basically encourage us to believe that you have to pay for anything more than 2 notes. You have to pay for a sample, which means, despite the fact these are creative, these could be fair uses, this is the kind of stuff we allow everywhere, despite the fact jazz and blues do this stuff all the time. So I think we actually have Chuck D from Public Enemy had some opinions about this and actually wrote a song about it, because I really like the idea that someone could be writing a song protesting copyright. It's sort of like, it's just not the kind of thing that normally happens.
So coming around, we were talking about how all of these things affect how music sounds. The sampling cases, in a very real way, affect how sample-based music sounds. Because we had 2 very poorly reasoned cases, which basically said if you sample anything more than 1 note, you have to get a license. And so we see a shift from early Public Enemy, Chuck D's part of Public Enemy music, sort of wall of sound, hundreds or thousands of samples, to much simpler music using fewer samples. And he said it changed our entire sound. But like Jamie said, listen to some Public Enemy, it takes a nation and billions to hold us back, talks about prison conditions, white supremacy, but it also talks about conditions in the music industry, and specifically about sampling and copyright law. And so here's how Chuck D felt about it. That's Ed Sheeran, that's not Chuck D. This is Chuck D.
Yo, I can't believe they got the PE in court before the judge on some nonsense. I got the S1s ready. Chuck Flame, what's up?
Court, now in court cause I stole a beat. This is a sampling sport, but I'm giving it a new name. What you hear is my PE, you know the time. Now what in the heaven does the jury know about hell if I took it? But they just look at me. Found this mineral that I call a beat, paid 0. They say that we stole this. I rebel with a raised fist. Can we get a witness?
And of course, Can We Get a Witness, also a great song by Marvin Gaye, all kinds of reference and sampling going on there. And I guess rap music less familiar to federal judges who would think that, oh, jazz does, you know, solos, oh, that's fine, but sampling just seems different somehow. Yeah, very interesting discussion. So I guess bringing this all together, which you really do in the book at the end, where does this leave us? I mean, on the one hand, stuff in your book kind of depressed me. There were, I mean, it's a wonderful book, but you're describing an industry which, like so many industries, has become ever more oligopolistic. Now the platforms and the record companies are basically fusing. The rise of AI could mean that we're going to be seeing sweetheart deals between big content and big platform, which will narrow even further our creative choices. We had a momentary period of a few years of trying to apply the antitrust laws. We've apparently given that up, which might have been nice. So that's the depressing side. But on the other hand, you say that there are more options than ever for artists to reach the audience directly, that there are ways of getting around intermediaries, there are different forms of creativity. Where do you end up?
I try to be optimistic, at least about the music, but I told my IP class that we might get through the lecture without anyone saying AI. Did you guys see that? You just said AI. But with the march of technology that we're talking about, that's the next frontier, which I get to in the book. But I'm cautiously optimistic. For one thing, the recent cases I told you about are trying to move that balancing act between control and freedom in the right direction. It will be interesting to see how things shake out with AI, and we have a lot of pending cases there. But if you told me when I was sitting here in law school in the mid-90s that I could have the the entire history of recorded music at my fingertips, I would have been like, I wouldn't have believed you, actually. And we do, and that's amazing. Artists who want to sidestep the lopsided provisions in recording contracts and go on their own, they do have mechanisms to do that. You can use an aggregator. You can find yourself on Spotify, and if you're lucky enough, there's more ways for artists to make money and to find audiences and to connect with audiences than before. So there's definitely hope here. And at the end of the day, the book is it's a love letter to copyright, which I love, and music that I love, but also all those components of the music ecosystem. And I mean, I had the same revelation, I think, while writing the book. Reality is interdisciplinary. The economics, the technology, the aesthetics, how all of those forces constantly come together to shape and to reshape the music that we love. It's not just the law in isolation, the rules on the books that we learn about in class. It's all of it. And so that's what I hope to convey. That's what I hope to achieve. And also, the very last thing I say in the book, to not lose sight of the people at the heart of the system, which are the artists, who are making all, they're sort of like surfing all these cycles of disruption and change. But at the end of the day, people are going to still make music. The music's still going to be great. And that's where I end up.
There we go.
There's my happy message, paraphrasing. The arc of history is long, really long, apparently. Staff of music is long, but it bends towards harmony. So I've left 4 minutes and 30 seconds.
I'll let you pick the questioners.
Nick.
I know you mentioned maybe not wanting to talk about AI, but I'm just going to throw the wrench in there. I'm just curious, what your thoughts are as we see an AI frontier where people are able to simulate voices more than anything, as opposed to just like sampling music, but literally crafting brand new music with people's voices. If you think copyright is going to be able to face that, or maybe if people will look elsewhere.
Legally elsewhere. I think that voice clones and all those capabilities, I think Jamie shares this opinion too, is going to make authenticity even more valuable. If I can listen to a song that sounds like Taylor is saying it and a song that actually is, that connection with the artist, I think, becomes even more valuable. In terms of whether copyright is the legal framework to address the legality of voice clones, it's not. Because there is this provision in section 114B that says you can imitate someone's voice exactly in a sound recording, and that's fine, as long as you don't dub sample the sound recording itself. And so, and that may preempt a lot of state right of publicity, personality rights claims for sound-alikes. Congress is making some noise about federal sort of deep fake legislation. Tennessee, on the state level, Tennessee's passed they managed to spell Elvis, their Elvis Act. And so I think there might be some movement. I'm wondering what you think, Chris, to have some sort of federal legislation that addresses the phenomenon, not only of voice clones, but deep fakes generally. Of course, a lot of so anyway, we may be going in that direction, but copyright's not the right legal framework to address it. And I'll let you guys decide whether you'd be satisfied by something that sounds like your favorite singer, but is not from them. I guess final thing, I like the if you can't beat them, join them. What Grimes has done is she's just offered her own voice clone. So she said, hey, go nuts. You can upload, you can go to her ELF tool, and you can just like sing something in there, upload it, and then her fake voice, her voice double will sing it for you. And then they'll help you distribute it and put it on DSPs on Spotify or something, and they take 50%. And so that's one of the ways of dealing with this phenomenon. It's like, you can't beat them, join them, it's gonna happen. Sure, have Grimes sing your song for you, and I'll take 50% of the bank. And so that's, that's one way of dealing with that kind of thing. I think I'm interested to see where it goes. Sir.
Thanks for the talk. Bit of a broad question. I was wondering if you could share a bit more of your thoughts on, I guess, copyright and consumer connectedness. I'm wondering if the latter is like a function of like platform choice. So when you brought up the Amazon Music, Spotify, Apple, et cetera, I hate subscription culture generally. But I think about how, you know, growing up, you had a sense of excitement if NSYNC came on the radio and it was Bye 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 or, you know, Rascal Flatts, whatever your song was, right? And nowadays, it's like you don't get to own a piece of the music as much, right? Maybe vinyl's making a comeback, but, you know, no one's going out buying CDs in the same way. And so, like, whether or not this is a consideration for legal teams, I think about, like, Kendrick Lamar, when he first dropped, like, Not Like Us, he sort of relinquished the copyrights, right? And it's like a way for consumers to engage. So just what your thoughts are on that.
Yeah, I have a lot of thoughts on that. So there is the criticism of subscription culture. I mean, it used to be there was at least some sort of interaction direct with the artist if you're buying their album or going to their show or actually choosing to listen to them. And now with streaming services, you have what's so-called lean forward music, where you're actually choosing, but you also have lean back music, where you're just going around doing chores or whatever, and the music is delivered to you. And so there has been a lot of concern within certain parts of the music industry that that's actually driving less fan engagement, less connection with the artist, and that's actually very problematic. It's, you know, you just have a soundtrack in the background, but it's not actually connected to the people who are making that music. And among other things, the streaming services are playing with royalty models. Sometimes they call it artist-driven royalty models and fan-powered royalty models to try to reward songs where the person actually goes in and chooses that instead of just sitting back and letting the algorithm deliver songs to them with better royalties, that sort of thing. But this kind of relates to the authenticity point. I share your concern about that, and I think with Kendrick Lamar, other people who are exploring different models where the primary goal is to connect with your fans. The secondary goals is how many clicks, how many streams. People may be streaming over 30 seconds on Spotify. I find those kinds of experiments very valuable, and I think different artists are going to be playing with those going forward. And I mean, you guys are all streaming your music. That's how you get it, right? So you can ask yourself whether your engagement now with the music you listen to and particular artists that you like is different from maybe when you were growing up and the streaming services weren't as pervasive as they are now yet.
I hear Drake is a real fan.
We almost got through the talk without Drake. Yeah, we're out of time, man.
Let's join together to thank Jennifer.